My name's Deputy Inspector General of Police, Dr. Shehu, PSC. To talk about PRAWA, Prisoners Rehabilitation and Welfare Action, we have a very, very good rapport, good understanding, and good synergy between the police and PRAWA for many years. It is an institution that concerns primarily on respect of dignity and human rights, which the police are supposed to be part of it. And also capacity building to the police to enable them to perform effectively and efficiently in conjunction with the fundamental respect to the fundamental human rights as enshrined into the Nigerian Constitutions of 1999. It's very, very beneficial, and at the same time in building capacity and enabling the police officers to perform credibly when they go out to discharge their duties. The police is an organization that deals with all kinds of human beings. When they come across a police officer, they deserve to be respected by police in ensuring not only their security and safety, but also in respecting their dignity and human rights. So in a nutshell, the training and retraining we are getting from the PRAWA is to enable us have police that will function and discharge their duties in a most standard and acceptable manner by members of the public. At this juncture, I want to say kudos. Welcome to the Nigeria Police Force online training.
Thank you for joining me in yet another very exciting class. We will continue our training on the children's rights. This is Module 3 of Course 5, and remember that this training is on human rights. In this course, we are going to be looking at the description and explanation of basic child's rights. At the end of this training, it is expected that police officers would be able to understand the basic principles in relation to child's rights, their rationale, and also to be able to explain them. Now, the objective of this training, basically, is to create awareness on the general description and explanation of basic child rights principles. We are going to be looking at a lot of international human rights principles. We are going to be looking at even regional in terms of African Charter on Children's Rights. We are going to be looking at all of these things to give you a holistic view of what children's rights is all about. Now, as an introduction, we are going to be looking at a broad scope of international human rights and how it provides a legal framework for protection of children. This section outlines in particular the international standards developed to support children who come in contact with the law and therefore with security agencies, whether they are victims, witnesses, or perpetrators of crime. So what we are saying is that what we are trying to look at here is the international human rights frameworks, and of course what is obtainable when children come in contact with security agents, whether they are victims or witnesses or perpetrators of crimes. These international human rights standards outline the requirements of states that ratified or otherwise apply them to provide services and structures necessary for children to develop their full potentials and more specifically for their rights to be upheld. So what we are trying to say is that this international human rights standard outlines what the state is supposed to do. States that ratified these international human rights principles, what they are supposed to do in order to develop the potentials of children to enjoy their human rights. Now, we are going to be looking at a lot of these international laws and standards. The first one we are going to be looking at is the Convention on the Rights of the Child, which of course came into, which was ratified in 1989 by a resolution of the United Nations General Assembly, Resolution 44 against 25 on the 20th of November 1989. But it came into full force in September 2nd, 1990. And Nigeria was among the 193 members that ratified this particular international law. Nigeria ratified it in 1999. We're going to be looking at some relevant articles in terms of police training. Now, first of all, we're going to be looking at the definition of a child. Who is a child? According to this international right, definition of a child is every human being below the age of 18 unless under the law applicable to the child majority is attained earlier. So what we're trying to say is that every child below, or every human being below the age of 18 is deemed to be a child. It doesn't matter whether the human being has grown, whether the person is 6 feet tall or 5 feet tall, it doesn't matter. Once the person is below the age of 18, that person is deemed to be a child. Then under this article, Article 2, describes protection of children against all forms of discrimination. Remember, we talked about discrimination when we are talking about your right as a police officer and, of course, the right of citizens. Every citizen is guaranteed the right against all forms of discrimination. And in terms of children's rights, this is also applicable. Article 3 talks about primary consideration of the best interest of the child. Remember what we discussed in our last module on this particular course? We said that everything we do regarding the children must be in their best interest, not in the interest of their parents, not in the interest of their guardians, but in the interest of the child. Then Article 3 also talks about the child's right to life, to survival, to development. Every child has the right to survive, has the right to life, and has the right to develop physically, to develop mentally, to develop even emotionally. Very important. Now, Article 12 talks about participation of children must be given due weight. It means that even children have a right, of course, to also have their view, to express their views. And this is very, very important. We'll look at another international law and standard. The second one we are going to be looking at is the African Charter on the Right and Welfare of the Child, 1990. And an African Charter of Right and Welfare of Child of 1990, reiterating the norms of the Convention on the Rights of the Child and the Declaration on the Rights of the Welfare of the African Child on non-discrimination. The best interest of the child, the right to survival and development and freedom is enshrined in Article 3 to Article 7. This is very important. We've said it already, that the non-discrimination of the child is very important. And this is in this particular charter, between Articles 3 and 7, it is contained. The protection of children from all forms of exploitation. You must pay attention to this. Economic exploitation, sexual exploitation. This is very important. Abuse, trafficking, sale, conflict or harmful cultural practices. And this is prevalent in Nigeria. You see a lot of children roaming the streets in terms of child labor, children who are now taken to homes to go and ask as house helps. This is not supposed to be so. This is against Articles 15, Article 16, Article 21, Article 22, Article 27, until Article 29. This is very wrong. Trafficking of children, sale of children, this is against international human right laws. And of course, Nigeria is a signatory to these laws, and it is your responsibility as a law enforcement officer to ensure that the rights of citizens of children is protected. Remember what we said in one of our courses. We said that your duty as the duty holder is to protect human rights, to promote human rights, and to help in the fulfillment of human rights. And of course, this also includes children's rights. I also want to mention cultural practices. We know cultural practices that, that is harmful to the child. Cultural practices, probably like female genital mutilation, which we've been preaching against, which of course endangers the life of the girl child. These are the kind of exploitation that is prohibited under Article 15 up to Article 29. Now, the right to special treatment of children in conflict with law, including to ensure that no child is subject to degrading punishment, that children are separated from adults, and that children are duly informed throughout the process. This is in Article 17. What it simply means is that in treating children, you must treat them with special consideration, knowing that they are still children. Now, another international law and standard we'll look at is the optional protocol to the Convention on the Rights of the Child on Involvement of Children in Armed Conflict, the OPAC. How do we treat children in terms of conflict? Now, under this international law and standard, it still defines the minimum age of a child to be 18. And it says that the minimum age that a person can be recruited into armed forces is at the age of 18. It is contained in Article 1 and Article 2. So what it simply means is that a child is not supposed to be recruited into the armed forces. A child is not. Remember that a child is someone who is below the age of 18. It means that when you are doing police recruitment, or you are doing the army recruitment, or you are doing DSS recruitment, or any of these security agencies, somebody who is below the age of 18 is not eligible to participate. Adoption of measures to prohibit and criminalize recruitment of children under 18 who are entitled to special protection from armed conflict. This is found in Article 3 and Article 4. What this is saying is that it is wrong for children to be recruited into armed conflict, and children are protected under Article 3 and under Article 4. In case of war, if there is war, children under 18 are not eligible, according to the letters and the spirit of this particular article, to participate in armed conflict. Article 6 and Article 7 talks about the prevention of the recruitment of children through promotion of protocol. You understand? Then it also provides that to take measures to demobilize, rehabilitate, and reintegrate children recruited or used in hostilities. This is important. Now, if for any reason children find themselves in armed conflict, participating in armed conflict, there should be need to rehabilitate, reintegrate them, and change their mindset, because that armed conflict has a way of changing the mindset of people who are involved in it. Talk less of children. So children who participate in armed conflict for any particular reason must be rehabilitated back into society. And that is, of course, contained in Article 6 and 7. Going forward, we'll look at the optional protocol to the Convention on the Rights of the Child on the Sale of Children, Child Prostitution, and Child Pornography, the OPSC. And this is very important. There are relevant articles we are going to look at under this law. The first one we'll look at is Article 1, which prohibits the sale of children, child prostitution, and child pornography. It means that children are not supposed to be prostitutes. They are protected under the law. Child pornography is prohibited under Article 1. Children are not old enough to watch pornography, and that is why when you see some movies, they will tell you it is rated 18. That is to tell you that if there is any child there, the child is not supposed to watch that movie. Article 3 talks about offenses that must be enforced and punished by criminal or penal law. This article provides, it lists, the things that when you do is supposed to be punished under the penal and criminal law. Article 7 talks about seizure of goods used to commit offenses and proceeds derived from offenses. Now, what it means is that if, for instance, there are goods, for instance, probably pornographic materials that children consumed or children watch, it means that it is, according to Article 7, those things can be seized because they are used to commit offense. Article 8 talks about protecting the child victims during criminal justice processes, adapting the procedures to their special needs, and providing privacy and protection. It means that when you are dealing with a child, you need to adapt your procedure to suit the special needs of the child. The same way you talk to an adult is not the same way you talk to a child. While talking to a child, you should be persuasive with the child, knowing that the person is the human you are dealing with is not an adult, but just a child. Article 9 talks about strengthening measures to protect vulnerable children and provide assistance to victims, including social reintegration and recovery. By this article is saying that we should take extra measures to reintegrate children back into society in terms when there is anything like armed conflict. The other one we are going to look at is the guidelines on justice in matters involving child victims and witnesses of crime. And this, of course, came into law in 2005. Now, there are relevant articles which we are just going to run through, the ones that are very relevant and very peculiar to what we are discussing in this particular module. The first one is Part 5. Interactions conducted with child victims and witnesses should be conducted in a child-sensitive manner and take into account their immediate needs. I've said this earlier. When you are dealing with a child, you don't deal with the child as if you are dealing with an adult. Children are supposed to be treated with greater care, with sympathy, and with compassion. So while you are treating them, while you are interacting with children, you must adapt your procedure to be able to meet the needs of the child. And that is what Part 5 is trying to say. Part 6 talks about child victims and witnesses should have access to a justice system that protects them from discrimination. Children should not be discriminated the same way you should not be discriminated. So victims should have access to a justice system that protects them from discrimination, be it discrimination on the basis of ethnicity, or be discrimination on the basis of tribe, or discrimination on the basis of religion, or even discrimination on the basis of social status. This is not supposed to be so. We'll run through and look at Part 12. Part 12 talks about child victims and witnesses that have right to safety and privacy. They should be protected from hardship or harassment through the justice process. What this means is that children should be given extra protection from harassment and from hardship. You don't subject a child to any form of harassment while in detention or while you are questioning the child, because the person is just a child and you need to adapt. Remember what we said, adapt your interrogation procedure, to suit the need of the child, knowing that the person you are dealing with is just a child. Lastly, we are going to look at Part 13. Part 13 provides that children also have the right for reparation, and where possible, all associated judicial costs must be addressed. What it means, you know what reparation means? Reparation means damages. When the right of a child is violated, the child also has a right to seek for redress. The child also has a right to enjoy damages and reparation because of the violation of his human right. And this is important. Now, the next one we are going to look at is the United Nations Standard Minimum Rules for the Administration of Juvenile Justice. This one happened in Beijing. We can call it the Beijing Rule in 1985 in Beijing, China. It came into effect in Beijing, China. Now, the relevant articles we are going to consider, we will consider Article 4, which says that the age of criminal responsibility must bear in mind the maturity of the child. Now, what it means is that the responsibility of the age of criminal responsibility must bear in mind that when it is a child, how old is the child? It has to bear in mind. It is not everybody that you send into a correctional facility. It's not every child that you subject some form of treatment. You understand? So you must bear that in mind when you are dealing with a child. Article 5 talks about promotion of the well-being of juvenile justice and principles of proportionality. This is very important. Promotion of the well-being of juvenile justice. It means that every country that is signatory to this law must promote the well-being of juvenile justice. The juvenile justice system must be in a manner, in a way and manner that it protects the interest and the rights of children. Article 7 talks about presumption of innocence, right to counsel, right to presence of parent or guardian, as well as right to appeal to higher authority. This is important. Now, every accused person is deemed innocent until proven guilty by a competent court of jurisdiction. This is not only applicable to adults. According to Article 7, this also applies to children, and it is very important. Okay, going forward, we are going to look at Article 11, Article 12, and Article 13. Article 12 talks about, whenever appropriate, police may divert the juvenile to community programs or services with the consent of the child or his or her parents or guardian. What it means is this. In terms of dealing with child offenders, in terms of dealing with juvenile offenders, we have to look for a way to commit the offenders to community service, not just taking them to correctional facilities or to juvenile correctional facilities. We need to explore the option of community programs and services, but with the consent of the child or with the consent of the child's parents or his or her guardians. Article 12 talks about training of special police officers or units who frequently deal with juveniles. This is important. I don't know if this is obtainable within the Nigerian police force, but according to Article 12, it is important that we have some form of training for special police officers to be able to deal with children. It's not everybody that has the gift of dealing with children. Some people know how to deal with children. Some people are not so confident with dealing with children. So it is important to have some form of training for police officers to deal with juveniles. We look at Article 26. Article 26 says that juveniles must receive proper care, protection, and assistance throughout the judicial process, notably when placed in institutional treatment. It means that if you have a child in institutional treatment, you need to show some form of extra care, sympathy for the child. Okay? The same treatment that is meted out to the adults is not the same treatment that is meted out to children. We're going to look at, in going further on this course, the United Nations guidelines for the prevention of juvenile delinquency. We call it the Riyadh Guidelines of 1990. Now we're going to look at the relevant articles under this particular convention. Part 1 talks about safeguarding the well-being and development of youths through provision of opportunities and community services. Okay? Part 3 talks about analysis of current problems and define strategies to prevent delinquency. What we are saying is, how do we prevent juvenile delinquency? By providing opportunities and community service. This is very important. When there is no opportunity for children, opportunity for youths to engage themselves in productive venture, what happens? You begin to see people engage in juvenile delinquency. Cooperation between different levels of government, community organizations, law enforcement agencies, and others in taking action to prevent juvenile crimes is contained in Part 3 of this particular law. It means that there should be cooperation between different levels of government, community organizations, faith-based organizations, law enforcement agents like you on how to prevent juvenile crime. And that is part of our responsibility. Part 5 talks about prevention of stigmatization, victimization, and criminalization of young persons. This is important. Please don't stigmatize the children. Probably somebody did something wrong. The person should not carry that stigma. Remember, he's still a child, and what we need to do is to see how we can correct that child and reintegrate the child back into the society, because that child can still be useful to society in future. We'll talk about now about the Havana Rules of 1990. That is the United Nations rules for the protection of juveniles deprived of their liberty. And this is very important. Okay? Part 1 talks about the rights, safety, and the physical or mental well-being of juveniles that it must be upheld. So in Part 1, the rights, the safety, the physical and mental well-being of juveniles are provided by in Part 1 of this particular law. In Part 2, the privation of liberty is only effected in conditions which continue to ensure the respect and protection of the human rights of juveniles. It means that if you want to deprive a juvenile of his liberty, if you must incarcerate a child, you must do so in conditions that continue to ensure the respect and protection of human rights of juveniles. What it means is that children in juvenile centers must live in presentable human conditions that are not dehumanizing. Their right to decency of life, their right to dignity of life must all be protected while in detention. We'll rush down to look at Part 4. Part 4 talks about the contact and an environment meeting requirements to human dignity, and that's what I just mentioned now, that the environment you are keeping the child must meet requirements for human dignity, and this is really very important. Now, we'll talk about the Tokyo Rules of 1990. The Tokyo Rules of 1990 is the United Nations standard minimum rules for non-custodial measures. We are going to look at that's non-custodial measures that doesn't involve incarceration or custodial measures. Now, the relevant articles in this particular Tokyo Rules are what we are now going to look at. We'll look at Article 2, Article 3, and Article 6. In Article 2, rules applying to all persons subject to prosecution, trial, or the execution of sentence at all stages of the process. This particular article provides for rules that must apply to persons subject, remember the persons we are talking about are children, rules applying to children subject to prosecution, trial, or the execution of the sentence. It means that at all stages, whether we are talking about the trial stage or the pre-trial stage, this particular Article 2 provides for rules that must be followed in the discharge of your responsibilities. Action 3 provides that offenders' rights cannot be restricted further than what is authorized by a competent authority. What it means is that when, for instance, a court of law rules on a particular case and provides certain sanctions, the restriction must apply to the extent of that ruling. It must not go beyond. So offenders' rights cannot be restricted further than what is authorized by a competent authority. We look at Article 8. Article 8 says that the rehabilitative needs of the offender, the protection of society, and the interest of the victim shall be taken into consideration. Rehabilitating the offender. When you have a child in custody, what we try to do is to rehabilitate the child, to protect the child, to protect also the interest of the child, so that the child can also be reintegrated back into the society. So the interest of the victim shall be taken into consideration, and that is very important. Now, going forward, we look at the guidelines for action on children in criminal justice systems as recommended by the Economic and Social Council Resolution of 1997, okay, of July 1997. We are going to now look at the articles under this particular law. Now, states, according to Part 2, should institute a child-centered juvenile justice process, including juvenile courts, along with panels of independent experts to review juvenile justice laws. What this Part 2 is trying to say is that states must take extra step to set up juvenile processes different from the normal courts that you have. There should be children's courts, then there should be a panel of independent experts who are also versed in juvenile matters to be able to handle cases that involve children. Also, Part 2 provides legal and other assistance to children in conflict with the law. Now, there are children in conflict with the law. Part 2 provides for legal and other assistance for children. When a child is in conflict with the law, the child cannot afford an attorney. It is the responsibility of the state to ensure that there is adequate legal representation for that child in conflict. Now, Part 2 also provides for improving programs that strengthen social assistance and reintegration to prevent over-reliance on criminal justice measures. What it means is that in Part 2, it also says that we need to look for a form of social assistance that helps to reintegrate children in conflict back into the society without relying explicitly on criminal justice measures, which most times has to do with custodial measures. Part 3 talks about child victims and witnesses are to have access to justice, fair treatment, restitution, compensation, and social assistance. It means that child victims who are children, they should have access to justice. They should have access to fair treatment. They should have access to compensation and restitution, that's reparation. And of course, they must have access to some form of social assistance. Informing child victims of their role and scope within the criminal justice process. You must inform the children of their role and the scope that the law provides that protects them and protects their rights when they are in conflict with the law. You must minimize delay in criminal justice process while protecting privacy of victims. And this is contained in Part 3. It means that we must remove all forms of delays while we have any form of criminal justice process involving juveniles. Going forward, we look at what we call the Lilongwe Declaration on Assessing Legal Aid in the Criminal Justice System in Africa. And this came into force in 2004. So we're going to look at some articles in the Lilongwe Declaration of 2004. The Article 1 talks about the responsibility to support the right to legal aid in criminal justice by adopting measures and funding transparent methods to deliver legal aid to all. It means that the state has the responsibility to support the legal aid involving juveniles, involving children. Remember, of course, in most cases, the children, of course, they don't work. They depend on their parents, on their guidance. So the state has to adopt measures that will help in delivering some form of legal aid to them. Article 2 encourages law enforcement agents to provide, to cooperate, and to promote legal aid at police stations, in courts, and in prisons. It means that police officers should be able to promote some form of legal aids. We have police officers who are lawyers. Of course, in part of in delivering their duties, what they can also do is to provide some form of legal aids, to juveniles that have cases in the law court. Article 4 talks about government officials. They must know that they will be held accountable for violations of the law and basic human rights. This is important. Understand that if the rights of the child is in any way violated, you can be held accountable for violating those laws. Going forward, now we are going to look at the number 10 of children's rights in juvenile justice system. That's according to the United Nations in 2007. In the opinion of the committee, the obligation of state parties to promote measures for dealing with children in conflict with the law without resorting to judicial proceedings applies. But it is not limited to the children who commit minor offenses such as shoplifting or other property offenses with limited damage and first-time child offenders. What Article 25 is trying to say here is that there are children who are petty offenders, maybe first-time offenders or petty thief, or petty theft. They just engaged in some petty offenses, that we should look for a way to explore non-custodial and non-criminal non-criminal measures. That means we don't need to start going through the whole hog of trying them in the court. There should be some form of community service that can be given to them to be able to carry out in a way to make them understand that they went against the law, and also trying to reintegrate them back into the society. Article 28 talks about the juvenile justice system should strictly limit the use of deprivation of liberty. And that's what I just said now. The deprivation of liberty means taking away the person's freedom of movement, putting the person in a detention home. So it is important, according to Article 28, to limit the use of deprivation of liberty, and in particular, pre-trial detention as a measure of last resort. Now we're going to move to Article 40. The training of professionals, such as police officers, prosecutors, and legal officers, and other representatives of the child is crucial and should take place in a systematic and ongoing manner. It means that police officers should be trained, prosecutors should be trained, legal aid providers should be trained on how to deal with issues regarding juvenile cases. And this is really very, very important. Now, continuing also on number 10, we are going to look at Article 42 and Article 44, and then we'll also look at Article 48. Article 48 provides the presumption of innocence is fundamental to the protection of the human rights of children in conflict with the law. What it means is that if there is any child in conflict with the law, the child is presumed innocent. It is fundamental, because even you, as a person, you also enjoy the right, because the law deems you innocent until declared otherwise by a court of competent jurisdiction. So Article 42 is re-emphasizing that fundamental, that it is fundamental that children must be presumed innocent even when they run contrary to the law, until proven otherwise by a competent court of jurisdiction. Article 44 provides that the child has the right to be heard. Very important. The child has the right to be heard. This right must be fully observed at all stages of the process. It means that when a child has a case, the child has the right to be heard during the pre-trial, during the interrogation, even in the law court, the child has the right to be heard. So starting with pre-trial stage, when a child has the right to remain silent, as well as the right to be heard by the police officer. It means that when a child is brought into custody, that child has the right to remain silent, and the child also has the right to be heard by the police, the prosecutor, and the prosecuting judge. It means that when a child comes into custody, he has the right to remain silent until he speaks with his attorney, or until he speaks with his parent or his guardian. That is very important. Now, Article 48 says that the police, the prosecutor, or the judge has to make sure that the child understands each charge brought against him or her. When you want to try a child, the child has to understand. That means you need to break it down to the child. The child may not understand your big grammar. Break it down in a language and in a manner. The child will understand this is the charges that are being brought against you. The state parties provide as much as should provide as much as possible for adequate trained legal assistance, such as expert lawyers or paralegal professionals. This is very important. It is important for children to be provided with adequate legal representation, and the person that is providing this legal representation must have sufficient understanding and knowledge of juvenile laws. This is very important. Now, in Article 49, the article provides that the people or the legal representatives to children must have adequate knowledge of juvenile processes and juvenile laws. They must be trained to work with children in conflict with the law. So it means that whoever is coming to represent the child must have adequate knowledge of juvenile laws, must know how to deal with children, must be trained to work with children under conflict. Article 56 talks about torture, cruel, inhuman, and degrading treatment in order to extract an admission or a confession constitutes a grave violation of the rights of the child. Remember, we discussed this in the previous module, and we said that torture, when we talked about prohibition of torture, Torture is prohibited in our law. According to the 2017 Act, Anti-Torture Act, it is explicitly prohibited. And more so when it involves a child. No child should be tortured. No child should be cruelly subjected to inhuman or dehumanizing condition. It is totally prohibited by our law. And according to Article 56, this shouldn't happen. Article 58 provides that police officers and other investigating authorities should be well trained to avoid interrogation techniques and practices that result in coerced or unreliable confessions or testimonies. That is just buttressing the fact, just buttressing Article 56. When you obtain confessional statements under duress, when you coerce a child to obtain information regarding a particular case, it means that what you are doing is actually wrong, because what the evidence you have obtained from that child may not be admissible before the law court because you collected it under duress or you obtained it out of coercion. Article 84 says that the right to challenge the legality of the deprivation of liberty includes not only the right to appeal, but also the right to access to the court or other competent, independent, and impartial authority or judicial body in cases where the deprivation of liberty is an administrative decision. What it means is that every child has the right to appeal. When a child is probably convicted convicted in court, the child has a right to appeal. The child has the right to legal redress. The child has the right to independent and impartial authority or judicial body in cases where the deprivation of liberty is an administrative decision. That is really very important for us to also note it down. Now, we are going to look at the United Nations Common Approach to Justice for Children, and we are going to look at Article 3. Article 3 deals with the integration of children's issue into broader effort. It means that every effort that we are taking as a state, as a country, we must integrate children's issue. Meaning we must integrate children's rights, we must integrate children's interest to become part and parcel of broader efforts. In institutional capacity development and training programs, it means that if you are training the police officers or if you are training legal practitioners, we need to also train them. We need to also build their capacity in terms of dealing with children. They need special training to be able to deal with children. So in capacity development, we must integrate children issue into it. In codes of conduct, standards of selection and recruitment, and standards of practice for professional, we need also to include children issues. What it means is that in the code of conduct for the Nigerian police, there should also be a particular code that deals with how police officers must relate and interact with children. In programs promoting the accountability of law enforcement, such as police accountability mechanisms or citizen review boards of police conduct, we must also integrate children's rights into these broader initiatives, and it is very important. Now, interventions to be strengthened in order to ensure full respect for children's rights, these things are important. If there are interventions, we need interventions to strengthen children's rights, and this is contained in Article 4 of the United Nations Common Approach to Justice for Children. Ensuring child's right education and legal awareness for all children. We need to train our children to understand their rights as children. We need to sensitize them what their rights are and what they are supposed to enjoy in those rights as contained in the Child Rights Act. Ensuring that children's concerns and their rights are included in peace agreements in discussion on transitional justice mechanism. This means that when we are having peace agreements in terms of probably one-ton countries or one-ton state or war-torn states, we also need to include the interest of the children in whatever agreement we are going to reach, the condition the children are going to live in, what the kind of their dignity to life, their right to freedom from all forms of discrimination. All of these things must be included in any peace agreement that states want to enter into. Developing the capacity of legal services, civil society organizations, paralegals on legal issues regarding children is very important for crisis and post-crisis situation. What it means is that we need to develop the capacity of people that deal with children so that they're able to understand better how they can provide better services to children under crisis and in post-crisis situations. In continuing this course, we are going to now be looking at our own national legislations that were enacted in Nigeria in order to promote and protect the rights of children. And we are going to be looking at the Child Rights Act of 2003. The Act is a legal document that established the rights and responsibilities of a child in Nigeria and provides for a system of child justice administration. This particular act was enacted in 2003, and it provides for the rights and responsibilities of a child and how we administer children and juvenile justice in Nigeria. A chapter of the Child Rights Act is dedicated to children in conflict with the law and family courts, which were established to deal with juvenile offenders. So what we're trying to say is that in this particular act, a whole chapter was dedicated to children in conflict with the law and what we are supposed to do with those kind of children. Now, UNICEF states that the Act has provided for child justice administration, talking about this particular Child Rights Act. Regarding children living under difficult circumstances, UNICEF remarked that the Act established institutions for servicing the needs and welfare of children living under difficult circumstances like orphan children, children in the streets, and those that are physically challenged. It means that this particular Child Rights Act of 2003 provides for how we'll deal with children who are in conflict with the law, or orphan children, or children. When we talk about children in conflict with the law, we're also talking about people, probably internally displaced persons, or juvenile offenders. Of course, this particular act provides for how we deal with them. Now, the Child Rights Act, unfortunately, is only enforced in the Federal Capital Territory, Abuja, and in a few other states that have explicitly enacted and domesticated this law. So we are really advocating for all the states in Nigeria to domesticate the Child Rights Act in order to further promote the rights of children. In states where the 2003 Act has not yet been adopted, the child legislation is based then on the Children and Young Persons Law of 1943. And of course, you will agree with me that 1943 is a very long time ago. So we need to bring our laws up to speed with contemporary realities, and that's why we are advocating that all the states in Nigeria should be able to domesticate the Child Rights Act. Now, it's been reported that laws between states differ principally, and this is why we are asking for all the states to adopt a uniform legislation, which is what this Child Rights Act of 2003 provides for. Now, one of the reasons why we are advocating for a uniform legislation regarding the children's rights is because of age of criminal responsibility and definition of a child. This is really very important. Now, the Child Rights Act defined the age or defined a child as someone that is below 18. When you look at the legislation in other states, it's as low as maybe 16 or 14, thereabouts. And of course, this now gives room for some form of violation. But if we have a uniform legislation, you can agree with me that that will take care of the rights of children in a better way. Now, we're going to look at the structure and the content of the Child Rights Act. The structure of the Child Rights Act of 2003 has been informed by the mandate to provide a legislation which incorporates all the rights and responsibilities of children and which consolidate all laws relating to children into one single legislation. What we are trying to say is that now the structure of the Child Rights Act is that it took into cognizance everything that has to do with children's rights, children's responsibilities. It consolidates every policy regarding children into one single legislation. Instead of probably looking at different legislations, 5 to 10 legislations, all of these legislations have been collapsed into one document, and that's the Child Rights Act. Now, the Act defines a child as someone who is below the age of 18 years. Underline the word 18. It doesn't matter whether the person is tall, whether the person is 6 feet tall or 5 foot tall, or whether the young lady has fully developed the features of a grown woman. As long as she is below the age of 18, she remains a child. It categorically provides that such a child's best interest shall remain paramount in all considerations. What it simply means is that once you are dealing with a child, the interest of the child, not the interest of his parents, not the interest of his guidance, is what should be paramount to you. A child shall be given such protection and care as is necessary for his or her well-being, retaining the right to survive and develop, and the right to a name and registration at birth. So what we are trying to say is that when it comes to children, whatever we are doing, we should take their interest into consideration and give them the opportunity to fully develop. Now, we're going to look at the basic provisions of the Child Rights Act. Provisions of freedom from discrimination on the grounds belonging to a particular community or ethnic group, place of origin, sex, religion, the circumstances of birth, disability, deprivation, or political opinion, and is stated categorically that the dignity of the child shall be respected at all times. Remember when we talked about human rights in the Nigerian police, we also talked about your own right, and we talked about your right to dignity of life. We also talked about your own freedom from discrimination. This right also, it also goes to even the child. The child has the right to be free from discrimination. The child should not be discriminated based on where he comes from. Whether the child is the son or daughter of the president, the child should not be treated differently because her parents are probably vulcanizers on the street. It means that we must treat children equally, regardless of who their parents may be, or whether they are Muslims or Christians, or whether they are Igbo, Hausa, or Yoruba. Nobody should be discriminated on the basis of whether religion, ethnicity, or social status. This is really very important. No Nigerian child shall be subjected to physical, mental, or emotional injury, abuse or neglect, maltreatment, torture, inhuman or degrading punishment, attacks on his or her honor or reputation. And this is very important. We are talking about the dignity to the human person. A child has that freedom to enjoy dignity of the human person. Freedom from any form of torture, whether it is mental torture or physical torture or emotional torture. No form of maltreatment. As the duty holder, it rests on you to ensure that children actually enjoy this right. So when you are seeing a child being molested or you see a child being tortured, it is your responsibility as a law enforcement agent, bearing in mind that this is against the law, to step in and say, no, this is against the law. Now, every Nigerian child is entitled to rest, leisure, and enjoyment of the best attainable state of physical, mental, or spiritual health. This is very important. Every Nigerian child must have that opportunity to rest. You mustn't be overworked. You mustn't be burdened by too much work. Unfortunately, we now live in a country where children are now the people providing for their parents. That's why we see children go hawking on the streets. This is actually not supposed to be so, and is against the Child Rights Act. Now, every government in Nigeria shall strive to reduce infant mortality. This is very important. And of course, this has to do with primary health care. It means that government should provide adequate and qualitative primary health care that will enable children to develop fully. We want to reduce infant mortality to the barest minimum. Provide medical and health care, adequate nutrition, and safe drinking water, hygienic and sanitized environments, combat diseases and malnutrition, support and mobilize through local and community resources the development of primary health care for children. And this is really very important. When we talk about malnutrition, Nigeria has one of the world's highest rate of malnutrition. I think Nigeria is actually the country with the highest number of malnourished children in the world. And we need to reduce this number because this is actually against children's rights. So provisions for children in need of physical protection measures. We're now talking about mentally challenged people, physically challenged people, or children on the street. Those vulnerable children, we need to protect them especially. We need to give them special protection, different from what we give to others, bearing in mind that they are vulnerable, or bearing in mind they are special cases because they are mentally or physically challenged. So this is really very important. Now, the Child Rights Act also provided that expectant and nursing mothers shall be catered for, and every parent or guardian having legal custody of a child under the age of 2 shall ensure its immunization against diseases or face judicial penalties. This means that if there is anybody in custody who has a child that is under the age of 2, that child, of course, is supposed to be immunized against diseases. And this is really very important, that someone is in incarceration or someone is in a correctional facility and the person has a child. That child is supposed, of course, to be immunized against diseases. Also, the law also provides that betrothal and marriage of children are prohibited. And this is why we are really saying that we need to make it uniform. The Child Rights Act needs to be domesticated in all the states of the Federation, because you realize that in some places, I'm not going to mention states now, you have issues of child marriage, where children under the age of 13, some 14, some 15, or 16 are actually betrothed into marriage, and this is explicitly prohibited by the law. It's not supposed to be so. So if we have a homogeneous and a uniform law that provides that the age of a child is from 18 years below, it means that we will have been able to deal decisively with the issue of child marriage. Now, causing tattoos or marks and female genital mutilation are punishable offenses under the Act, and this is really very important. You know, we have issues of female genital mutilation, which of course causes other issues in the girl child. We have issues of vaginal cancer today, and this is chiefly because of things like female genital mutilation. But in the CRA of 2003, it is expressly prohibited, and of course it's really very important. And so also is the exposure to pornographic materials, trafficking of children, their use of narcotics or narcotic drugs, or the use of children in any criminal activities, abduction and unlawful removal or transfer from lawful custody, and employment of children as domestic helps outside their own home or family environment. This is really very important, and I wish we can really take this out to all Nigerians to really understand what is contained in the Child Rights Act. It says that domestic help, using children under the age of 18 as domestic help, is actually against the law. But what do we see today? Children under the age of 15, under the age of 13, are now used as domestic help. Issues of pornographic materials is also prohibited. Trafficking of children is prohibited. Use of narcotics, use of drugs. A child under the age of 18 is not supposed to consume alcohol. It is wrong. Okay? Now, child abduction and forced exploitative labor, which is not a light nature or in an industrial undertaking, are also stated to be offenses. What we're trying to say now is that forcing children to do hard labor, exploitative labor, using children or forcing children to go and work. You have the situation where you have children working in construction sites. That is actually against the law, and the law expressly prohibited it. Now, buying, selling, hiring, or otherwise dealing in children for purpose of begging, hawking, prostitution, or for unlawful immoral purposes are made punishable by long terms of imprisonment. This is really very important. Hiring or otherwise dealing with children for the purposes of begging. We have street beggars today, children who are used to beg. That is against the law. Hawking, which of course have become very prevalent in Nigeria. In our major cities, we see children hawking sachet waters. We see children hawking galas on our street. That is actually against the law. And that is why we are asking for the domestication of the Child Rights Act in all the states of the Federation, so that children can enjoy the rights that has been given to them by our laws. Other offenses considered grave includes sexual abuse, general exploitation, which is prejudicial to the welfare of the child. In terms of exploiting a child, using a child to beg, that's exploitation. Recruitment into the armed forces. Remember what we said earlier when we said that a child under the age of 18 is not allowed to serve in the armed forces. And the importation or exposure of children to harmful publications, talking about pornography or scary publications that will, bring fear to the child, is not supposed to be consumed by a child. It further preserves the continued application of all criminal law provisions securing the protection of the child, whether born or unborn. And this is also very important. Now we're going to look at child justice, juvenile justice. What does the Act provide for when it has to do with judicial processes involving a juvenile or a child? The Act makes provision for the establishment of family courts. You could call it juvenile courts. The courts, which will operate at the High Court and Magistrate Court levels, have been vested with the jurisdiction to hear all cases in which the existence of a legal right, power, duty, liability, privilege, interest, obligation, or claim in respect of a child in issue, and any criminal proceeding relating thereto. All of this long grammar is trying to say that the family court is supposed to be responsible for dealing with issues that has to do with children, the interest of the child. Any claim that is regarding a child is supposed to be treated by the family courts. The Act has provided for a child justice administration to replace the juvenile justice administration of old, which has been in existence for several decades in Nigeria. The provisions prohibit the subjection of any child to the criminal justice process and guarantees that due process shall be given to any child subjected to the child justice system. So what we are trying to say is that this Act prohibits subjection of any child to criminal justice process. If there is any case involving a child, it should go through the juvenile justice process, not through the criminal justice process. And this is really very important. It has prohibited also the use of capital punishment, use of imprisonment, and use of corporal punishment for children under 18. And this is really very important because they are still children. So this Act prohibits expressly the use of capital punishment, imprisonment, or corporal punishment. So this Act actually advocates for use of non-custodial measures or community service in dealing with issues involving our children. These are novel provisions because in the old Child Rights Act, it was not contained in those provisions. But the Child Rights Act of 2003 made some very novel and progressive provisions in order to safeguard the rights of a child. The Act frowns at institutionalization for pregnant children, teenagers, and expected mothers. What are we trying to say? Some underage pregnant girls, the Act actually frowns at institutionalization, meaning, keeping them in a remand home. It's not supposed to be. But where institutionalization is desirable or unavoidable, it mandates the establishment of special mother centers for pregnant mothers or teenagers, while children residential centers and children correctional centers are to be established to replace the present approved schools created under the CYPA. The CYPA is the Children and Young Persons Act, which is, of course, the old Act. Now, what we're trying to say now is that in case of institutionalization, what we are not going to have is special mother centers for pregnant mothers or teenagers, which is better than the correctional center, because in those centers it provides for the necessary tools that will make their lives a bit more comfortable than what you would have in the correctional facilities. Now, children living under different circumstances. What does the right say or the Act say about children living under very difficult circumstances? Much along the principle of creation of all institutions for serving the needs and welfare of children living under difficult circumstances like orphans, street children, and those that are physically challenged are provisions for the establishment, registration, regulation, and monitoring of community children's homes. What is it trying to say? It is saying that now, for people who have homes for children, this Act also provides for some form of regulation, how probably the home is supposed to be, in terms of the size, in terms of the standards, in terms of what you're supposed to provide before that home can be approved as being an approved center for teenagers or for children. It provided for the supervisory functions and responsibilities of the minister having responsible for children in relation to various children's homes, which includes monitoring, provision of financial support, research, and returns of information on activities of these homes. What it is trying to say now is that the minister had the responsibility to always, investigate, to always visit some of these remand homes, some of these children homes, to see if what they are doing is in line with the Child Rights Act of 2003. We've come to the end of this particular module. I want to encourage us to go through the slides, go through the material that has been given to you for a better understanding of what the children's right is all about. I'll see you in the next class. Thank you.